Attorney Jeff Roberts says a negligent entrustment case against your company can be built on what you should have known about a problem driver.
Let me start off by drawing a little bit of a distinction between negligent entrustment in the private sector, where a parent might let a child use their car, and in the commercial sector, where an employer allows an employee to drive a car. In the private sector, in the first example of the parent and the child, negligent entrustment, to prove that a parent has negligently entrusted the car to a child or to somebody else, we ordinarily have to prove that they knew that the child had some kind of unfitness to drive, that the child had told them, I got a DUI, that the child had told them, I have multiple tickets. In the context of the commercial entrustment of a vehicle, it's not limited to just what the employer knows. Negligent entrustment can be assessed against an employer if they should have known about an employee's unfitness to drive. Because in the commercial sector, employers are expected by industry standard to first check every employee's driving record before allowing the employee to drive a vehicle. Second is the employer is expected to check the motor vehicle records of employee drivers on an ongoing basis. The industry standard is a minimum of 1 time per year checking the motor vehicle records. That is from literature, that is from pretty much universally accepted by fleet managers that I've spoken with, as well as experts in the field. So an employer cannot say, wait, we're not negligent for entrusting the vehicle because we didn't know, we didn't look. No, in fact, if you don't look, you're negligent. If you don't look for a length of time, and you can still be held to be negligently entrusting a vehicle. I think there's a lot of fleet managers out there who are under the mistaken impression that if you don't check a driver's record, that's the way of avoiding negligent entrustment just by burying your head in the sand. And that's not the case.